Hello again, everyone. It is Rob Ryder, and today we're going to talk about by what authority, and particularly about the unauthorized practice of law by licensed and unlicensed attorneys. And the unlicensed probably believe they're licensed, but they're not. They didn't complete all the steps. So you need to forget in your head that you're involved in a traffic citation or a foreclosure or IRS violation or whatever else it is, and instead look at it from the side that, well, by what authority do whoever it is bringing this charge against me? And there's a way to tell. So let's just look at the state stuff, or let's keep it simple. Or I'm not going to get into the federal yet. Let's stick with the state stuff. You go into a court, and right, all the attorneys in there are supposed to be licensed to practice law within the state of whatever. But a lot of people have asked, "Are you an attorney?" or right, "Are you licensed to practice law?" We never ask them. Well, are you? And then make them prove it. And that's kind of what this is about. Is let's ask them for the proof. Because if they're not, then the entity that has jurisdiction over the matter is the Supreme Court of the state. The Supreme Court is the one that handles the jurisdiction over the practice of law within the state. At least in the 3 or 4 states I looked at, and I just expect it to kind of follow through. So you could use. So my point is, you can use this for any situation, right? But you need to look at it from a little bit different perspective. So here we go. We're talking about basically professional misconduct or false personation, right? Because judges and attorneys are judicial, i.e. public officers. Or that person is committing a false personation. It's really that simple. Either you are, right, because it says you can go read what it takes to be one, and you read a little bit further. Judges, I think everybody would agree, yeah, they're supposed to be a public officer, but so are attorneys. They're officers of the court. Always considered in court, and they take an oath of office. I don't mean the one with the Bar Association. I mean the oath of office they take in a court, and so forth. So they're officers of the court. I covered this in other videos. It's not rocket science. So, but did they do what they needed to do to be who they say they are? Okay, so you want to be a judge. You say you're a judge. Well, did you properly run to be a judge? And did you do an oath of office to be a judge? And do you have a bond to be a judge? And well, it's no different with an attorney, right? Okay, you say you're an attorney. Did you go to school to be an attorney? Right? Did you get a degree to be an attorney? Did you go and take an oath to be an attorney? Did you have any other criteria that you needed to fulfill to be an attorney? Can you produce a certificate of good standing as an attorney? And there are going to be those that can. I mean, having the license really isn't that. I believe most of them probably do have a license. The ones that don't have a license are ones that didn't go and swear. They swore an oath, maybe in a ceremony, but they didn't subscribe their name to one as a memorial to the event. And so, for instance, here's a. Right, this is a. It's from 1987. But this is what I would call a license, attorney's license. And here at the bottom, I mean, this is the part that matters, is where this is what the clerk is subscribing, saying that David N. Recklenberg has been regularly licensed and admitted to practice as an attorney and counselor of law within the state, and has duly taken the oath to uphold the Constitution of the United States and a little bit hard to read, Constitution of the United States and of this state, and have the oath of office prescribed by law. So he took an oath of office, right? Well, it's an office in the state. and that I now duly, I can't read the rest of it quite, unfortunately. But anyways, this is his law. This is his license, right? And it's a license for David N. Reckenberg. Now, N is definitely, well, you would think that's an abbreviation for something, first letter initial. But this is where it gets important, because if that's the name that he has in his license, then that's the name he has to put on his paperwork. This is 1987, right? And it's proper case name, right? That's what this one looked like. And we'll look at another one here in just a second. But so they do exist. It isn't that they exist. It's, does the guy you deal with, does he have one? So judges and attorneys are judicial, i.e. public officers. And as officers agreeing to a particular code of conduct, they are duty bound to inform disciplinary boards of violations of their code of conduct, which includes the unauthorized practice of law. And so we'll look at a few things where it says, look, you guys you've joined an organization that really is run almost like its own little government. It's got a general assembly, which is all the attorneys that are licensed to practice law, and they get together once a year and they elect representatives and commissioners and president and vice president and secretary. These are all offices that get elected, almost like, if it's a municipality. Well, they have their own code of conduct, and so if you're in that clique, right, you've agreed to the rules. And all that is under the Supreme Court. So, continuing on. It is November 3rd, and I cannot pay my rent. I didn't pay my rent, man. I was supposed to pay it 3 days ago. Can you help? Please do. You could, PayPal account is Ashley Ritlewski, or that's my snail mail. And I'll leave it on there just for a second. Why don't you stop it right now, pause the computer, and write that down. Maybe you can help me out. Because this is going to help you out if you got a situation going on. Let's take some more looks at things. So here are some of the things that they being the government, say in different states about the practice of law. Arizona practice of law. Rules for admission of applicants to practice law in Arizona. Rule 31. Supreme Court jurisdiction over the practice of law. Jurisdiction, any person or entity engaged in the practice of law or unauthorized practice of law in this state, as defined by these rules, is subject to this court's jurisdiction. Right? So you don't need to go anywhere with this except to the Supreme Court. Now, they're going to have a way they want you to do it, but you're dealing with the Supreme Court. Unauthorized practice of law includes, but is not limited to, engaging in the practice of law by persons or entities not authorized to practice, pursuant to some paragraphs, or specially admitted practice pursuant to another paragraph. Or using designations lawyer, attorney at law, counsel at law, law office, J.D. Esquire, or other equivalent words by any person or entity who is not authorized to practice law in this state pursuant to some paragraphs. Are they the same paragraphs? No, these are paragraphs 38. Right? Now, just last week when Roe was in court, and she was talking to her public defender about this, her public defender told her she never signed an oath of office. Right? She went to a swearing in, raised her hand and did that, but she didn't subscribe her name on an oath. If you ain't done that, you don't have a frickin', you're not an attorney. You may be considered a law student still, and you can join the bar because they take law students and so forth, but until you take an oath of office and hold the office, well, you're not an attorney. And so if you're acting like an attorney, like she is, that's the unauthorized practice of law by somebody who's not an attorney, but holding themselves out to be one. The other side of that is, so I'm going to real quick, let's look at this, guys. Here's a more recent style of certificate or license, if you want to call it that. Call it a certificate of good standing, I guess. It's from the Supreme Court, and look at the Supreme Court is over the state of Arizona. I think that's just stunningly obvious that that's what that means. Right? Who runs the state? The court does. Which court? The Supreme Court is over the state of Arizona. So, Matthew John Bowles, right? This guy used his full middle name. And this is where we get into, this is the name that has the license. But if you go to Matthew John Bowles' website, if you put that name in right now, lawyer, Arizona, boom, you're going to find his website. And on his website, he's Matthew J. Bowles. If that's how he's signing his paperwork as Matthew J. Bowles, then he's not doing business, or he's not an attorney licensed under that name. This is the name that has the license. And this is all caps name. The other one was upper lower case. This is all caps. This is from 2010. The other one was from 1987. I think something happened in between there. But this says, having exhibited to the justices of the Supreme Court of the state satisfactory evidence of good moral character and qualifications to practice law, is therefore hereby authorized. He's authorized to practice as an attorney and counselor in the Supreme Courts and all other courts of this state for and during good behavior in said practice. It's got the gold seal of the Supreme Court, signed by the Chief Justice and the clerk. All right, it looks pretty much legit. 2010. All right, this guy is authorized to practice law. Who is? Matthew John Bowles, not Matthew J. Bowles. Now, a lot of times, the other thing they do is they may sign it Matthew J. Bowles. Let's say like that on the website, or that's what they give the state to say this is my legal name. And then out in the field, they'll be signing the name M, right? Initial M, John Bowles. So they flip it up, and that's what a circuit court judge is doing here in Michigan, that I've shown on many times in different videos. But just last week, if you go look at his name on the State Bar website, it's Patrick William McGrady. Maybe it's got Patrick W. McGrady on there, one or the other. But then on the way he signs his name and that he ran for office and as a judge, it's P. Williams O'Grady. Well, how would you know that those are the same two people? Right? That's why they had to get a license for a particular name, and so that's the name they need to use, and this is what we need to stick them with. Are you using the name that you have licensed with the state? A little more on this. So, Bob in Arizona had an issue with a traffic issue a couple years ago, and we had tried to do a few things with it, and it ended up that when he was in court, it was the assistant city attorney that was in court in a place called the city court. That's what it says on the door. But the city court really isn't there. The city court is actually called the municipal court, and it's in the city hall. Go figure. We'll talk about that some other time. But anyway, so Bob's had this in his mind ever since then. There's been something wrong. So he called to the clerk of the court and said, hey, is whatever the guy's name is, just the way he found it on the Surprise City website, right? Is this guy listed as an attorney? And whatever it was is within a middle initial. And the clerk came back and said, no, we don't have anybody that name. And he said, well, are you sure? I mean, I'm sitting here looking at the Surprise City website, and I'm looking at his name. It's right there. You sure he's not an attorney? He says here he's the assistant city attorney for the city of Surprise. And the clerk went away from it and came back in and said, no, it isn't. In fact, what I suggest you do is you call, and it was like the Judicial Oversight Committee for attorneys in Arizona. Right, so if you give them the name that you see it on the paper with the initial, they're going to tell you, because they have a master roll of attorneys, if they're on there or not. So, okay. Let's see what else they say. All right, so if you use those letters, right, you better have a license. Unprofessional conduct means substantial repeated violations of oath of admission to the bar or the attorney's creed of professionalism of the State Bar of Arizona. Right? They got it looks like they're taking a creed too. Creeds are ecclesiastic. I haven't read that one yet. The Lawyer's Creed of Professionalism. Authority to practice, except as herein provided in Section D, no person shall practice law in this state or represent in any way that he or she may practice law in this state, unless the person is an active member of the state bar. Restrictions on disbarred attorneys, members of right to practice. No member who is currently suspended or disability inactive status, and no former member who has been disbarred shall practice in the state or represent in any way that he or she may practice in the state, may practice law in the state. They got to quit calling themselves a lawyer or an attorney or an esquire or a JD, or they can't use those words anymore. Michigan. All persons who are licensed to practice law in Michigan must be members of the State Bar of Michigan. In order to become a member of the State Bar, you must first take steps to become admitted to the State Bar, right? Multiple steps. If you've recently passed the bar exam, the Board of Examiners has mailed you a certificate of qualification. Right? So the bar itself isn't enough. That's one step. A current active member of the State Bar must file this certificate and a motion seeking your admission to the State Bar in the Supreme Court or a circuit court. In the Supreme Court or a circuit court. You must also appear personally in open court to be administered an oath of office. And then it says, view the ruling, which if you go read that ruling, it tells you the oath they're going to take, and then it says number 2, the applicant is required to subscribe such oath of office by signing a copy and to register membership in the State Bar of Michigan in the manner prescribed in Rule 2. So there's still more to do, right? You had to get the piece of paper saying that you passed the school, then you had to get the piece of paper saying that you swore an oath, and you're still not a member. But continuing on, prescribed in Rule 2, and these rules, and to pay the required dues before practicing law in the state. The clerk shall record such admission in the journal of such court and shall preserve such oath of office in the records of the court. A roll of all persons admitted to the bar shall be kept in the office of the clerk of the Supreme Court. Who's got the list? The Supreme Court does. Membership. Those who are licensed to practice law in the state shall constitute the membership of the State Bar of Michigan, subject to the provisions of these rules. Law students may become law student section members of the State Bar. None other than members' correct names shall be entered upon the official register of attorneys of the state. Each member, upon admission to the State Bar and in annual due statements, must provide the State Bar with members' correct name and address and such additional information as may be required, which has to do with this. The other additional information is this trust banking account they have in which they keep their clients' money or property and that of third parties. Well, if you're not their client, but you're in some kind of proceeding with them, then you're the third party they're talking about. When you go to foreclosure, they already got the property in an account. They're just trying to get it, to be in their name. Oh, okay, so none other than a member's correct name. This is the important part, right? Correct name, correct name, correct name. Illinois, who governs practice law? The practice law in Illinois is governed by the Illinois Supreme Court. Thank you very much. The Illinois Supreme Court's roll of attorneys is a list of attorneys admitted to practice in Illinois. The roll includes the name of the lawyers even if they are not registered on the Attorney Registration and Disciplinary Commission. So although they have this other list called the ARDC, the list is with it's called the Illinois Supreme Court's roll of attorneys. Why? Well, because the Illinois Supreme Court is the one who governs the practice of law within the state. So it's their record that matters. And that's why when Bob called now this is Illinois and I'm talking about Arizona, when Bob called in Arizona and he called to the clerk's office, she's the one that has the official list. The clerk of the Supreme Court. Now you're going to have to verify this on your own in your own rule books, but it isn't that hard to find. Admission of lawyers into your state, whatever the name of the state is, right? Lawyer registration in your state. and just start clicking around the website a little bit, and it'll show you the different laws and so forth they got to follow. Right? But one thing that they make really hard is if you want to change your name on the Illinois Supreme Court's roll of attorneys, you must file a motion with the clerk of the Supreme Court requesting to change your name. The motion shall be in the form of a formal letter. The motion letter should include the name under which you are currently listed on the roll. You must provide documentation evidencing your name change. Right? So this is a legal name change. And then basically it says, that if the clerk agrees, or if the court agrees, you can have your name change. And you send it to the clerk, right? So the clerk of the Supreme Court of Illinois is the one that has the master. They call it the Illinois Supreme Court's roll of attorneys. This is the, you get in the habit of just getting some general name for things, and I guess it's probably best to use the name they use, right? Because you can go and say, I'm looking at, wherever this came from. At the time it was in one of their rules, right? You can say, you can tell the clerk, I'm looking at rule whatever in whatever book it is, and it says here that you have this thing called the Illinois Supreme Court roll of attorneys. And which Roe did, and she said, yep, I do, and but if you want the information off it, you have to mail me. She wouldn't give it over the phone. But for Bob, they said, well, no, the dude you're talking about with the middle initial isn't on our list of attorneys. And I suggest you contact the disciplinary board. So, okay, hang on just a second here. Let me go load some new papers up. Okay, now to show that this applies to judges too. Now here's an oath of office, Associate Judge, Circuit Court, State of Illinois. Before we get into Elizabeth K. Flood, see, she used her middle initial. I wonder if that's how she did it on the state bar website. Let's find out in a second. But notice it says filed in the Index Department February 7th, 2013. Now, I don't understand that, because they appoint these associate judges on July 1st of whatever year they get appointed. Right? They basically get elected by the circuit court judges from these people that are in the bar. Right? That's number one thing. You had to be licensed to practice law. Well, who are they? They're all members of the state bar, which is its own association. So these judges get together and they appoint people from within the association to these other associate judge offices. And a lot of these people are people that come from the, as you can imagine, from the prosecutor's office, the state's attorney's office, things like that. So, Elizabeth K. Flood, excuse me. When you look at Elizabeth K. Flood up online, her full license name, according to the ARDC, the Attorney Registration and Disciplinary Commission of Illinois, is Elizabeth Kathleen Flood. So as far as her license is concerned, that's the other one. All right, Elizabeth K. Flood doesn't exist. All right, Elizabeth K. Flood doesn't exist. And her oath, if this is what this is supposed to be, is an oath, which it says it is, well then this oath has got an improper notarial act that's been done to it by one Judith M. Brokow, and now she's using the middle initial and she calls herself a chief judge. Well, Elizabeth K. Flood and Judith M. Brokow, we'll look at hers. Right here's Judith's. That's how she signed it. And we don't even know who did this one. This guy doesn't have a name on there. Who knows who that is? Right? These aren't oaths of office. They've not been done properly. In fact, we turned this stuff in to the Inspector General of the Executive Office Inspector General, who's gotten a hold of Roe and said, yeah, they have jurisdiction in this matter, but they don't have jurisdiction over counties, and they don't have jurisdiction over courts. And at the time, I didn't know what that meant, but then I was reading this. Oh, well, the Supreme Court says they have jurisdiction over court officers, so basically they have jurisdiction over courts. But both of these attorneys, because you had to be attorney number one, have used a name other than Judith Mary, not Judith M. They didn't use the name that they have given to the state bar, the Supreme Court, basically. The clerk of the Supreme Court has Judith M. Braucow as having a license to practice law. Right? Not Judith M., Judith Mary. Judith Mary can practice law. We don't know who Judith M. is. So all this stuff would have to be pointed out, which is what we're doing right now, to the, in Illinois, it's the Attorney Registration and Grievance Commission, and they have a form you can fill out, a complaint form, to complain about the unauthorized practice of law or whatever. So to me, this isn't a judicial matter, because the dude, the lady, whoever it is, right, they did it as being an attorney who could practice law in the state, and they've done it incorrectly. So it has more to do with their attorney credentials than it does their judicial credentials. They're not a judge. This isn't an oath of office that's been subscribed by a notary. Right? This isn't. They don't have any seals on it. You know, that kind of stuff. If you know what notaries are supposed to do, and you were looking at this as being done by a notary, you say, "Well, this isn't done right." Forget that it says circuit judge. How's a notary supposed to do it? Right? So, that's my point, I guess, is there you go. This applies to judges, right? So, you can say, well, by what authority is that judge sitting there? And by what authority is this public defender here? And by what authority is that prosecutor there? And let's start there. And I can ask them for it, but I don't need to get it from them. I can go to the Supreme Court. And if they don't give it to me, I say, well, the dude's here practicing law within the state. You got a problem. Right? Or it's the false personation, or it's official misconduct. And so they've written, all sorts of rules for these guys. Now this is to do with Indiana. Right? Here's rules to admission to the bar. So if you're going to go look for this stuff, just take some of these key words and go, put it in with using the name of your state instead. Pennsylvania, rules for admission to the bar. Right? And then you want to find the part that talks about discipline of attorneys. Right? But here's all the different rules. And so if you were going to point out a infraction, you would say per rule whatever, let's say 22, oath of office, found in the Indiana Rules of Court, rules of permission to buy, blah, blah, blah. Right? You write it all down one time. Hereinafter known as rules. Right? They got one that says what they're supposed to do to take an oath of office. But mainly I did this just to highlight some stuff and go through it. So what does it say in Indiana? All right, so you can see this stuff comes out of official documents. I'm not just making it up. That's what their stuff says. All attorneys, well, let's start. The bar of the state consists of all attorneys in good standing who prior to 1931 were duly admitted to practice law in the circuit courts of the state. Something happened here in 1931. And all attorneys in good standing who subsequently thereto have been or hereafter shall be admitted to practice by this court. Well, what do they need to do? First, you got to register. All attorneys in active and inactive good standing duly admitted to practice law in the state of Indiana shall file with the clerk of the Supreme Court, 216 State House, Indianapolis, Indiana, that particular address, their correct name, office and residence address, office telephone number, electronic mail, and county of residence. If they change their name, they got to let them know in 30 days. The names and addresses so filed shall be effective for all notices involving licenses as attorneys and or disciplinary matters, and a failure to file same shall be a waiver of notice involving licenses as attorneys and in disciplinary matters. All right, they got to register with the clerk. On or before October 1st each year, every attorney admitted to practice law in this state shall certify to the clerk of the court that all clients' funds that are nominal in amount or to be held for a short period of time by the attorney so that they could not earn income from the client in excess of the costs incurred to secure such income are held in an account. This is where they're taking your money and they're putting it into the account. And in my opinion, they're the ones living off the interest, and we're not getting any. But they didn't steal your property. It's just sitting in these accounts, and they're drawing the interest off it. Registration fee must be paid on before October 1st. Certification required of this rule and some other rule to be filed the clerk before October 1st. So this is something I do annually. Failure to pay registration. Any attorney who fails to pay registration fee is required under some sections or fails to file the certificate required in another section shall be subject to suspension from practice of law and sanctions of contempt of court in the event he or she hereafter engages in the practice of law in the state. So, forgetting what their little thing is, it's contempt of court to practice law within the state without a license. So tell them that the dude who wrote go to your foreclosure if you have one, find the damn attorney of record for the other side, look his name up on the state website and see if the name's the same, and if not, start bitching. Certification of good standing. The clerk of the court shall issue a certificate of active good standing or inactive good standing approved by the court to any attorney upon receipt of annual registration fee and any applicable delinquent fees referred to in the section respectively. The certificate of active good standing shall include statement to the effect that the lawyer has filed the certificate required in section F of this rule. So you ask them for their certificate of good standing. Right? If they can't produce that, right away, well, they got a real problem. So the very first thing you do when you get involved with these guys, so I'm going to need your certificate of good standing with the state bar. I need to make sure you're an attorney. They can't say no. They have to give it to you. Well, they don't have to, but if they don't, you're going to go to the disciplinary board and say, hey, this guy's practicing law without a license. Get his business card. Find his name online, whatever he's doing. As soon as it looks like he's saying he's licensed to practice law and the name he's using isn't the name that's on the license, well, he's doomed. Doomed, I tell you. Admission of attorneys. The Supreme Court shall have exclusive jurisdiction to admit attorneys to practice in Indiana. Admission to practice law by the court pursuant to Rule 21 shall entitle attorneys to practice in any of the courts of this state. Again, who has the jurisdiction? Exclusive. Supreme Court. Right? So you're going to take your action to the Supreme Court through an investigative arm that is set up, some kind of Grievance Commission. And what you need to do is point out something that they have jurisdiction over, which they say they have jurisdiction over the unauthorized practice of law. And that's what you're going to point out. And now, we're going to take it to the trier of the fact and show them the facts. Role of attorneys. A record shall hereafter be made and entered on the order book of this court of the admission, enrollment, resignation, suspension, disbarment, reinstatement, this court, addition, the clerk of this court shall keep, and from time to time revise, permanent alphabetical index card, alphabetical card index roll of members of the bar of this court who have been enrolled as such, showing the name, address, date of admission of each living member. We're not talking about the dead. Each living member. Their proper person. Not their fictitious entity. I don't know if I did any more or not in this, but They got lots of rules they got to follow. Oh, I did. Here we go. Admission. The applicant who is eligible for admission under the foregoing rules may be admitted by appearing in person before the bar of this court and by taking the oath hereinafter set forth and is after establishing to the satisfaction of the court the applicant is a person of good moral and character and fitness. Upon being admitted to practice in the state of Indiana, each applicant shall take and subscribe, not just take and subscribe. What does that mean? Subscribe. It means when you write your name on a piece of paper. Roe's attorney, public defender, didn't do that. To the following oath or affirmation. And they made him write a book. The one in Illinois is like 5 lines or something like that, right? This is a paragraph and a half. Nevertheless, each person granted the privilege to practice law in this state has the obligation to behave at all times. It's an obligation. It's a moral obligation. At all times, in a manner consistent with the trust and confidence reposed on him by this court, in a manner consistent with the duties and responsibilities as an officer or judge of the courts of the state. I guess attorneys are officers of the court. The Supreme Court, exclusive jurisdiction of all cases in which attorney who is admitted to the bar of this state, of this court, or who practices law in the state, hereinafter referred to as an attorney, is charged with misconduct. The Supreme Court's got exclusive jurisdiction for misconduct by attorneys. Grounds for discipline or suspension: any conduct that violates the rules of professional conduct or the Code of Judicial Conduct heretofore adopted. I haven't looked at the Code of Judicial Conduct yet. Boy, we even got more to look at. I mean, they're just breaking all sorts of laws. Starting with, they're not doing the easy one. Always stick to the easy, right? Make them get past the point where you're not putting your name down the way it is on the license. I say that's practicing law without a license. Composition of Supreme Court Disciplinary Commission. A disciplinary commission to be known as the Disciplinary Commission of the Supreme Court of Indiana. Well, that's pretty easy, right? If you're in Indiana, you're looking for the Disciplinary Commission of the Supreme Court of Indiana. Hereinafter referred to as the Commission, is hereby created and shall have powers and duties hereafter set forth. 9 members, 7 who will be admitted to the bar, and 2 lay members. 2 people who aren't admitted to the bar. Now, one other interesting thing. Now, so we've talked about people who may not have a license at all, and people that do have a license, but they don't seem to be using the name that's on the license. Then there's the other group, the ones that do appear to be using the name that's on the license. Those are few and far between, so far as it looks. But there's a reason they're that way, and those are the people. If you're going to go talk to an attorney, that's the one I would talk to. The one that does it the same on his paperwork as it is in the records of the court. And what we're going to do, we're going to see, it doesn't matter if they have a license and they're not using it, doesn't matter. They have a license. And since they have a license, they're under the Code of Conduct. And so if we point out to another attorney that we believe that this attorney is doing business unethically because he's not using the name of it on his license, the attorney you just told that to is morally obligated to go turn him in. And if he doesn't, well, then you get a twofer. You turn them both in. That's how you skip the stone. Powers and duties of the Disciplinary Commission. Appoint with approval of the Supreme Court an executive secretary of the commission who shall be a member of the bar of the state and who shall serve as pleasure of the commission. Powers and duties of the executive secretary. Administer the commission's work. This is what I want to get into. Investigative. Upon receipt of written verified claim of misconduct, which you would be sending, from a member of the public, a member of this bar, a member of the commission, or a bar association, hereinafter referred to as the grievant, the completion of such preliminary investigation as may be deemed appropriate, the executive secretary could dismiss it, or determines that it does raise a substantial question of misconduct, so you give presumptive evidence to the trier of the fact. Send a copy of the grievance by certified mail to the attorney against whom the grievance is filed, to the address that the guy gave him. So you can't say he didn't get it, because that's the address he gave him to send mail to. And shall demand a written response. There you go. All right, then it goes from there. Now it's just a court case. Hearings. But you're not the one prosecuting it. The Grievance Commission is. Well, prosecution of grievances. If the commission determines that there is reasonable cause to believe a respondent is guilty, right? So who's the commission now? They're acting like a grand jury of misconduct, and the misconduct would not likely result in sanctions greater than public reprimand if successfully prosecuted, and if blah blah blah. Okay, so there are different things they can do. However, in the event the commission determines the misconduct is proven, would warrant disciplinary action, and should not be disposed of by way of administrative admonition, the executive secretary shall prepare a verified complaint with sets forth the misconduct which is the respondent is charged, and shall prosecute the case. The complaint shall be entitled, "In the matter of." Okay, so you're providing an information, basically, to an attorney general, who, upon his review, says, yep, that's what it is. He's going to prosecute it in the matter of, and he's going to do the prosecution. I don't know if he is, but somebody there is going to do the prosecution. And they got their own hearing officers, right? This is all an administrative court that is going to handle attorney grievances. Judicial, okay, so then judicial disciplinary proceedings, which would be different than attorney, right? These are judges now. And they want you to handle it different. I'm not going to go in and read it all, because I'm still not convinced. I say, well, they were never a judge. Right? They don't have an oath of office. They were never a judge. There's no bond. They were never a judge. They weren't elected properly. They didn't follow the election laws. They were never a judge. Don't call them a judge. It's an attorney who's guilty of misconduct. At the best. Other than that, it's just a usurper. Okay, so that, again, this was called the Rules for Admission to the Bar and the Disciplines of Attorneys, and this is for Indiana. And so I hadn't seen a book like this in the other states, but it's the reason I'm using it. You may want to download it and see if you got one like it. You know, use it as a reference guide to go find certain key phrases. When you find a phrase, oh, okay, use that phrase and then put your state name instead of Indiana and see what pops up on the screen. And then, so one of the things it said they had to follow was the Indiana Rules of Court, Rules of Professional Conduct. And they got plenty of them, but this thing seems to be kind of the same for most states, because it's always in the fives, like 5.5, the Unauthorized Practice of Law, where it says, a lawyer shall not practice law in a jurisdiction in violation of the regulations of the legal profession in that jurisdiction, or assist another in doing so. A lawyer who is not entitled to practice in this jurisdiction shall not, except as authorized by these rules or other law, establish an office or other systematic and continuous presence in the jurisdiction for the practice of law, or hold hold out to the public or otherwise represent the lawyer is admitted to practice law in this jurisdiction. And again, this gets down to if they hand you a business card and it's got the middle initial on it, man, they're busted if you go online and find out, oh, you used your middle name for the you used your middle name. In some circumstances, a lawyer who practices law in the state of Indiana pursuant to some other paragraphs, shit, man, I got this just the wrong size, may have to inform the client that the lawyer is not licensed to practice law in the state of Indiana. For example, that may be required when the representative occurs primarily in the state of Indiana and requires knowledge of law of the state of Indiana. There you go. If they're practicing law in the state of Indiana, they need to, have a license from the state of Indiana. Oh, I want to go down, and then it's in the 8s. So then that was the 5s. Down here in the 8s. Here we go. An applicant for admission to the bar or a lawyer in connection with the bar admission application or in connection with a disciplinary matter shall not knowingly make false statement of material fact, fail to disclose a fact necessary to correct a misapprehension known by the person to have arisen in the matter, like, hey, you're not using the right name, or knowingly fail to respond to the lawful demand for information from an admission or disciplinary authority, right? Which is why, we want them to go ask them, not us. Let the disciplinary authority go ask them. Except that this rule does not require disclosure of information otherwise protected by Rule 1.6. Reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of the rules of professional misconduct that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. Well, how is the lawyer going to know another lawyer is violating the rules of professional conduct? Well, you're going to tell them. See, I don't know how all this works, so I'm just going to tell you, because I know if I tell you, you have to do something about it. Keep me in the loop. Send me a copy of the complaint you sent in. Or just do it yourself and contact the disciplinary board. But if you've hired an attorney, here's the reason I'm bringing this up. If you've hired an attorney for some reason, you're going into court, then tell the attorney, hey, I want you to check this other dude out to make sure that he's practicing under his license. And if not, make sure you turn him in because he's in contempt of court. And how about the judge? I don't think he is either. Right? And then see what they say. A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority. Yeah, he doesn't have a frickin' oath of office and he's not using the proper name, and you can't use two different names. Right? If you've taken an oath as an officer, as an attorney, that's the same name you got to use to take another office in the same court as a judge. There's not two of you. There's only one. Misconduct. It is professional misconduct for a lawyer to violate or attempt to violate rules of professional conduct, knowingly assist or induce another to do so, or to do so through the acts of another. Commit a criminal act. Well, that's what false personation is and official misconduct. That's a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, fitness of a lawyer in other respects. Engage in conduct involving dishonesty, fraud, deceit, misrepresentation. Engage in conduct that is prejudicial to the administration of justice. Prejudicial, I guess. State or imply an ability to influence improperly a government agency or official, or to achieve results by means that violate the rules of professional conduct or other law. Knowingly assist a judge or judicial officer in conduct that is a violation of applicable rules of judicial conduct or other law. There are enough things there to point out to somebody that those are all considered misconduct. And the one I'm saying that it starts with is the mere fact that they don't have a license. If they do have a license, they're not using the name that's on the license. And if they have a certain name on a license and they go take the office of a judge, they had better use the same name as on the license. And almost all the time when you go look online at what the license says, it has the full middle name. And, it says on all these things we've read that it's, they got to give them the correct name, they got to certify the name. It has to do with the name. Well, what name are they writing on the piece of paper? Right? And just because they have a registration number or something, it doesn't mean they have a license or that they're doing business under their license, and that's what we need to investigate, as we are right now, by sending in some complaints. I'm going to show you one more complaint and then wrap this one up. Hang on just a second. Okie dokie. Where did I hide it? Here we go. So here's Michigan's. We have a thing called the Attorney Grievance Commission. And I think I talked about this in my last video. But this is what the form looked like. And so I filled this out and sent it to a brother named Jerry, who has an issue with this particular court. And we'll see if he's going to use it. If not, I may just send it myself. But this has to do with attorney information, Patrick W. O'Grady. Right? Now that's what this gentleman is called on the State Bar website. And this is the address they give, 31 Division Street, Coldwater State. All that came right off the website. Phone number, all that stuff. Right? But I didn't hire him. And I'm not even saying it's about a particular kind of case. I left that kind of open for Jerry if you want to put something in. But this is what I said. One Patrick W. O'Grady, with that P number, claiming to be an attorney licensed to practice law in the state of Michigan, duly elected to the office of Circuit Court Judge, and currently holding the office of Chief Judge, is involved in official misconduct or false personation as an officer of the public. I don't want to say officer of the court because I want to cover it all, public. Documentary evidence from the record of the county of Branch, included with this complaint, evidences Patrick W. O'Grady signing an oath of office for the 15th Circuit Court Judge in the fictitious name of P. William O'Grady. And there it is. P. William O'Grady. That's how he's signing his oath of office, but that isn't the name that he has as his attorney name. An official notary misconduct of David T. Cole. Well, because David must not have checked the dude's identification, because he let him put it down that way, and that isn't the name that's on his bar card. One Patrick W. O'Grady, in the fictitious name of P. William O'Grady, witnessed the oath of office of alleged probate judge. Right? So, first of all, this is Patrick's, done by David T. Cole. Right? But David T. Cole, P. William O'Grady isn't the guy's name, right? So you allow somebody to fill an office that under a false name. So I don't know what you're guilty of. Negligence, for sure. But it gets worse, because then this guy, right, P. William O'Grady, now he's been made the clerk, now he's saying he's the circuit court judge. Well, he's going to sign the oath of another judge, the probate judge. But he was never the judge, so the probate judge isn't the judge. And this is the famous false seal of Michigan, where this critter on the right here is looking back over his back when he should be looking in towards the center. So, all these things have happened, right? So, P. William O'Grady witnessed the oath of office of an alleged probate judge, because he's alleged, because P. William O'Grady isn't a judge, to witness, on which he has affixed a counterfeit seal of the state of Michigan. Finally, a fictitious public bond for one William O'Grady. Now it's not P. William O'Grady, I think it's just William O'Grady. Let's look at the false bonds. All right, this is supposed to be a public official's bond. It's kind of crap to try to put past you, right? Here it doesn't have P. William, it's just William O'Grady, Circuit Court Judge, Branch County, $10,000. Signed, sealed, and dated 10th of March, 2014. Well, geez, when did he take office? You got any dates on this? 2009. Right? Anyways, they just made these up back in March when we were in there asking questions. They wanted to throw something at us to get us out of the office. But, right, so it's a false bond. Which was created by Michael L. Reimner, whoever the hell he is, and offered to complainant as evidence of compliance with state law. Patrick W. O'Grady and unknown others are involved in a conspiracy of antitrust activity, stripping the people of God of their personal property, which is really what they're doing. And then all that's left in this form is just a one-page form. Is you put your name, signature, address, city. You don't even need to swear to it. Right? So this is the way it's done with judicial officers. Now, I'm not going to talk about it right now anymore, but police officers, the only person that can arrest you is a peace officer, which is a public office. Peace officer. He's the only one that can arrest you. And so if you've been arrested, there better be evidence of a peace officer arresting you, and a peace officer would have to use his full name in his signature, just like we're talking here. You can't call yourself Trooper Peters, right? It's John Henry Peters, whatever your name is, their name is. And so, but those kind of things you wouldn't bring to the Supreme Court necessarily, because they have jurisdiction over those in the judicial branch. But it would seem that you could take that to internal affairs, which is what I really think you should do. Is you take to internal affairs, say, hey, this dude didn't fill this ticket out properly, and you don't wait until it's court. You do it as soon as you get it. Just drive down when they give you the ticket, drive down to the freaking cop shop and give it to internal affairs, and say this guy's guilty of official misconduct, or it's false personation. I don't believe that he is a peace officer. You're going to have to show me the evidence that he is. But beyond that, he didn't sign his full name, so it's official misconduct by a peace officer if you happen to be one. So, that's all these things come down to. It's by what authority are they doing what they're doing, right? Let's see their authority. So, okay, I'm going to leave it there, and you all have a great day. I hope you find it useful. If you can, please do donate, because I couldn't pay my rent, and I kind of worried about that. It's hard to do this when your stomach's empty. I need some help. Appreciate it. Y'all have a great day.